Morning, everyone, and we are delighted to have you join us for this webinar. My name is Professor Fionnuala Ní Éileáin. I am presently the United Nations Special Rapporteur on the protection and promotion of human rights and fundamental freedoms while countering terrorism. I'm also a Professor of Law at the University of Minnesota Law School and at the Queen's University of Belfast, Northern Ireland's Law School. I'm delighted today to be the moderator for this event, which is being hosted by the Special Rapporteur's mandate. We are really pleased to be launching today a report that has sort of the product of much work over the past year, much consultation and much engagement with many of the people who are joining us on the call. The title of the report is The Use of Biometric Data to Identify Terrorists, Best Practice or Risky Business. We are going to run through some house rules first, or just the order of the morning, and then or afternoon, depending on where you are. And then I'm going to briefly say a couple of words about the sort of rationale and the process for producing this report. And then we're going to hand over to the panel. And we hope to leave enough time for lively discussion to have many of you, and we know there are many experts joining us on the call this morning, to engage with us on the substance of this report. So first of all, let me just welcome you and welcome the 4 panelists that we have invited to join us to help us launch this report today. I'm going to briefly introduce our panelists. I should note that, that we have 4 women on the panel today, which I'm going to say in the context of a discussion on tech, terrorism and regulation is really great. Many of us are often the single woman sitting in such panels, so it's very nice to have a gender, not a different kind of gender balance on the discussion today. And we have 4 extraordinary speakers, and I'm going to introduce them briefly one by one. I'm going to start with Dr. Christina Hurtzi-Orban, who is the legal advisor to the mandate and also a research fellow at the Human Rights Center at the University of Minnesota Law School. Christina leads the mandate's work on this area of technology and counterterrorism, human rights interface, and has been responsible for leading on this report. So I'm really glad that she's going to join us to share her expertise with you today. And we are also really pleased to have with us Mr. Koda Hove, who's the policy officer at Privacy International, an organization that the mandate works extremely closely with and is delighted to be collaborating with again today. And thirdly, I'm going to introduce Ms. Anna Maria Sesma, who is the United Nations Security Council's Counterterrorism Executive Directorate's representative today. She's a policy officer there and also an expert in this area leading their work. The mandate has a very close and really productive working relationship with UN CTED. And so it's really, we're particularly pleased to have CTED join us in this discussion, and really glad to have Anna Maria with us, whom we work with on a number of projects and engagements. And finally, I am delighted to welcome Ms. Karen Melcher, who's a member of the European Parliament. And her work is also really focused on some of these issues, and her concerns really dovetail with many of the issues that we will be addressing today, technology and rule of law interface in particular. So we're really delighted to have someone who's actually grappling with the day-to-day policy implications and trying to steer the law in the European Union in really positive directions joining us. So that's who our panelists are. Let me also just acknowledge the support of a couple of institutions that have made this report possible. The first is the University of Minnesota's Human Rights Center, who's hosting us today and has also provided support to the completion of this. But also we had particularly financial support from the Knowledge Platform on Security and the Rule of Law's Knowledge Management Fund. This is a really important, has been a critical stakeholder to allow us to get this work completed. We were also really, as a result of that, able to engage in a number of bilateral and other consultations with key stakeholders, including at RightsCon in 2019 in Tunis, which now seems a long way away as we are all online and not going anywhere exciting. But we were glad to have the chance to discuss many of the issues in this report in other contexts. Let me briefly, and I'm just going to take a couple of minutes to briefly describe why it was that the mandate felt it was so important for us to do this work, and why I particularly stress the interface of technology and human rights in the counterterrorism space. We have for a long time been concerned in general about the marginality of human rights practice and discourse to counterterrorism regulation. That has been a consistent theme of the work that the mandate has done both over my tenure, but that of my two predecessors. But we have been particularly concerned about exploring the interface of human rights in the technology and counterterrorism space, a space that seems to be growing both exponentially, but also where the capacity and the expertise at the human rights level seems particularly challenged or marginalized. The human rights implications of the use of biometrics in counterterrorism are particularly acute in light of UN Security Council Resolution 2396, which, as many on the call will know, creates an obligation, and I'm going to quote, to develop and implement systems to collect biometric data. In that case, to responsibly and properly identify terrorists, including foreign terrorist fighters, in line with international human rights law. So we have a clear Security Council resolution mandate in this space. And though, as the mandate will address in more detail when Christina presents, while this is presented as if you want, a retail obligation, meaning focused on specifically on terrorism and foreign terrorist fighters, in reality, the applications of these measures are wholesale. They attend to large population and large groups. The result of that mandate, as it were, in the Security Council resolution has meant that there's a clear need for human rights guidance to properly identify what is meant by the term in compliance with human rights law. Now, there is some guidance out there, and the mandate acknowledges that some effort has been made to address that. We see the Madrid Addendum and the Biometrics Compendium as a start to acknowledging that there is a need for human rights guidance in this space. And they do, both of those guidances make reference in particular to privacy and to children's rights. But from the mandate's point of view, our concern was that both the compendium and the Madrid Addendum really don't address the totality of the human rights needs in this space, or start from the premise that human rights has to be hardwired in at every single step of the biometric data process. And so what we wanted to do in producing this report was actually start the process of naming what that would look like. And instead of critiquing, coming up with a set of solutions for actually doing that kind of work. And so while acknowledging that that is out there, we see the need for, and that's this report fills that gap of making sure that there is concrete, specific, highly detailed, and really a capture of the wide array of human rights implications of the totality of biometric data use. We also, I think, want to make clear that it is particularly important that this happen in the context of the acceleration that we're seeing in the COVID-19 space, where the use of technologies are being fast-tracked in many contexts, and also where the kind of natural barriers to adoption, where people think about issues like privacy, due process, freedom of association, freedom of expression, all of these other rights seem much less significant given the context of the pandemic and people's fear of the pandemic. And so we think it's a particularly important time to launch this report in the context of the kinds of challenges that our human rights are facing in the context of data collection in this space. And I should note that the report made specific reference to COVID and has a freestanding section on COVID to guide some of the discussions that are taking place in the present moment. Let me close by saying that in addition to the report, we have short documents that are recommendation documents, and those have been translated to Arabic and to French. So the goal is to make these recommendations widely used. And going forward, we plan in the next year to undertake a multi-stakeholder consultation aimed at developing concrete human rights principles on the use of biometrics in counterterrorism. And we believe that this report is going to help inform and push that project forward and actually give other stakeholders, including CTED, the Office of Counterterrorism, but also governments and regional organizations, some concrete and specific suggestions on what they need to do in this area. So with that, I'm going to stop. I'm going to hand over to Christina, who's going to introduce the body of the report. And each speaker has been given 10 minutes, and I'm going to remind them to stick to that. And we encourage you to use the chat function to ask Q&A so that we can guide the questions once the speakers are done. So over to you, Christina.
Thank you very much. And thank you to everyone joining. We are very grateful and excited to have you participate in this launch event. I would do my best to present the main findings and some of the recommendations of our research in the 10 minutes. And I would try to share my screen. Let me see if it works. I hope that you can all see it. As the Special Rapporteur has already mentioned, our research has been driven on the one hand by the adoption of Security Council Resolution 2396, but also by the developments relating to the ubiquity of biometrics, relating to the fact that the use of biometrics has been becoming increasingly common and relevant data and technology is more easily available to many actors, including both state and private actors. The Special Rapporteur has already referred to Resolution 2396, and I know that other speakers will also speak to the context provided by the resolution. So I am going to be very brief in setting out some of the ramifications that were particularly relevant for us. Even though this resolution is not the only one or not the first one to address the use of biometrics in a counterterrorism context, it is the resolution that established an obligation on member states to develop and implement biometric systems and to collect biometric data. And what that means is that these obligations are binding on 193 UN member states, many of which do not have adequate human rights, including privacy and data protection standards set up under domestic law, and some of which have very discouraging records when it comes to their human rights compliance, in particular in a national security and counterterrorism context. The measures imposed, as the Special Rapporteur has already flagged, come with potentially far-reaching human rights implications, and I will come back to this as well in a bit. The measures that are required under the resolution require considerable resources and capacity, in particular if these measures are to be applied and implemented in a human rights compliant manner. Many states currently do not possess these resources and that capacity, and some of them actually flagged this shortcoming already at the time of the resolution's adoption. Now, when it comes to the human rights component, of course, the resolution does require states to implement all measures in line with domestic and international human rights law obligations. However, there has been no human rights risk assessment conducted prior to the adoption of the resolution in relation to the measures that have been imposed under the resolution. And as a result, the resolution lacks detailed human rights guidance, with all the caveats that the Special Rapporteur has already mentioned and that I'm sure Anna Maria will discuss in more detail, related to the developments brought by the addendum to the Madrid Guiding Principles and to the Biometrics Compendium that has been developed by the United Nations. Now, the only entity that has been explicitly tasked with the monitoring of the implementation of the resolution, including the human rights compliance of the implementation, and whose analysis and findings can inform the Security Council in this respect, is CTED. And one of the main tools at the disposal of CTED are the country assessments. From a human rights point of view, of course, the challenge here is that these assessments are confidential and will not be public unless the state in question agrees to the publication. And so far, none of them have agreed to have these assessments public. For this reason, I think we are particularly lucky to have CTED join this panel so that they can shed some light on ways in which they are assessing and advising states in this respect. Now, this is the background against which the mandate decided to embark on this research and to contribute to bridging this human rights gap when it comes to the use of biometrics in a counterterrorism context. And our analysis and resulting recommendations were built on two main preliminary findings. And these preliminary findings will sound very, very obvious, in particular to those with a human rights background. However, they also represent very poignant gaps. And if these were duly considered when domestic regulation is developed and implemented, we would be having a very different conversation right now. So these two premises that we based our analysis on is that first, biometric data is sensitive personal data that should be protected as such in law and in practice. As biometric data is, of course, unique to each person, and it is highly representative of that person and allows for the identification of individuals. And with the help of technology, certain types of sensitive information not immediately detectable to the naked eye can also be discerned from biometric data. And for all these reasons, from a human rights perspective, we consider that biometrics-based technologies are to be considered high-risk technologies. And we find that very important to flag. Also because during our heard the argument that technology was neutral, which means that good actors will use technology in a human rights compliant way, while bad actors will be using it in a way that violates human rights. And we can indeed see that biometric tools are a very potent tool in the hands of oppressive or authoritarian governments, but we also see that the more rule of law conscious actors also face challenges when it comes to the human rights compliant use of biometric tools. And this is because, in our view, technology is rarely neutral. And when it comes to data-driven technology, it is highly unlikely for that technology to be neutral. And for this reason, I would like to emphasize that we do need to focus on the actor, but we also need, and the user of the technology, but we also need to focus on the technology itself if we want to understand the depth of human rights challenges in this area. And I know that one of our speakers will address these issues through concrete examples that arise at the domestic level, and I am very excited already to hear their presentations. Now, when we looked on the basis of these two premises at the human rights implications linked to the use of biometric data and tools, some of the very obvious findings were that, of course, a human rights compliant approach to biometrics is not possible without properly considering the right to privacy and recognized data protection principles, which means that states must develop and implement domestic legal and policy frameworks that properly protect both the right to privacy and data protection. And with respect to data protection, I would like to flag that in a number of jurisdictions, data protection principles either do not apply or apply in a restricted amended format when it comes to data processing and data handling in a national security context. And while some restrictions may be warranted in a national security context, in the view of the mandate, it is important that nonetheless, national security data processing and data handling still happens in line with internationally recognized data protection principles. At the same time, it is very clear that the human rights implications that are linked to the use of biometric tools and data are much broader than just the right to privacy and data protection. Both because the right to privacy serves in a way as a gateway right, and violations of the right to privacy may result in violations of a number of other rights, but also because the use of biometric tools, and in particular, automated or algorithm-driven use of biometric tools can negatively impact a series of other rights, in particular the right to non-discrimination, due to the inbuilt biases that, real-life biases that are reflected in the technology and in ways in which the technology is used. Now, when we try to figure out what a human rights approach to biometrics would look like, one of the leitmotifs that you will find in our report, repeated many times and emphasized many times, is that we need a comprehensive human rights risk and impact assessment. And we need that kind of impact assessment, both with respect to data handling, as well as with respect to looking at the design, development, and implementation of biometric tools. With relation to data handling, I would like to flag that the lawfulness of human rights restrictions or interference with human rights needs to be assessed at each and every stage of data handling and usage, including collection, retention, processing, sharing, and so on. And one of the reasons why we would like to flag this is because we saw very serious shortcomings in this respect. Many systems are set up to conduct some level of human rights assessment at certain stages, for example, at collection, but do not repeat the human rights assessment at subsequent stages. And due to the particularities of the data lifecycle, this may result in violations during subsequent usage, and this may result also in a continuous violation. For example, of course, an unlawfully collected data set cannot be lawfully retained and cannot be lawfully processed. Now, as I mentioned, when we look at the human rights-minded approach, this should also be considered when it comes to the development and deployment of biometric tools. And here the report flags the very important role that businesses are playing, having in mind that most of this technology is, of course, developed, deployed, sold, or transferred by businesses. And the report flags that the UN Guiding Principles on Business and Human Rights set up a comprehensive and very useful framework in this respect. They require that business exercises due diligence, that they have human rights policy commitment, that this commitment is actually translated into operational policies. The main issue in our view is that in practice, the UNGP's implementation by businesses leaves quite a bit to be desired, but this implementation also leaves quite a bit to be desired on part of states. And for this reason, the report came up with a series of recommendations on safeguards relating to high-risk technologies that should be considered, of course, by states as the main human rights duty bearers, but also businesses who are active in this space. And one of the main issues, one of the main elements that the mandate is recommending is setting up and implementing comprehensive authorization and licensing systems by governments with respect to technology that presents a high human rights risk. And such frameworks must be binding both on public authorities as well as private actors such as businesses. And these systems must be developed through a human rights conscious approach and cover all relevant stages of development, deployment, sale and transfer, as well as post-sale and post-transfer maintenance, and must contain inbuilt human rights safeguards, including independent oversight and transparency. Now, I would like to conclude with basically referring back to a statement that I made at the beginning, saying that our premise has been something that probably seems very obvious to many of our attendees. And I think that in a way also many of our findings and recommendations may seem quite evident. And for me, this is both good news and bad news, because it means that we do have an international human rights framework that properly governs issues related to the use of biometric data and biometric technology. It also means that states and private actors do have tools at their disposal to properly implement this framework and to properly implement relevant safeguards. But it means that this, in practice, this implementation and this consideration for the safeguards that already exist is not happening. So our challenge is how to influence relevant stakeholders to start putting together these pieces in a meaningful manner that will lead to a better and a more human rights compliant use of both data and biometric tools in counterterrorism. And this is something that I am happy to discuss during this webinar. On this slide, you can see the link to our report, and we are of course happy to also post that link in the Q&A for those of you who would like to consult the report in more detail. Thank you very much, and I'm handing back to Fionnuala.
Great, thank you. And I think the one thing the mandate would stress is there are two words that you take away from this webinar and this report are the two words every stage, because that I think is the overwhelming message that the mandate is seeking to imprint from this work, which is that is not a selective process to apply human rights, that it has to be comprehensive, and that this every stage motif is the key guarantee point to ensure the protection and promotion of human rights. Let me now turn to our second speaker. I'm going to invite Coda to speak to us, who's going to talk to some of the real life and practical challenges that Privacy International have documented on the ground, specific jurisdictional analysis to just remind us that these issues are not abstract. They're actually very, very concretely and really felt in individuals and groups' lives, and to sort of bear that in mind, that this isn't an abstract technological conversation. It's a very concrete conversation with implications for human beings. So Coda, over to you.
Thank you very much. It's a pleasure for us to be here and sharing our research findings as well as our experiences. So I will just share my presentation. Okay. Seem to just okay. For some reason I'm having an issue with that, but okay.
Well, do you want to send it to Katie, and we have a facilitator, so we can if you could start, but then we can maybe catch you up if there's a technology glitch on a technology webinar. So all right.
Yeah, okay, I'll do that. So yeah, so our findings are our experiences from 3 countries, or 3 experiences. Most of the time when we talk about biometric experiences, it's usually very simple sometimes to tell these are good actors, these are bad actors. But from our experience and from the examples that I'll give now, the 3 examples are, in summary, the first will look at how biometrics have been used by Israel in the Palestine region. And then the second one will be how a multitude or different state actors, both military and non-military, in Somalia have come up with biometrics and how they've used them. And then the third one will look at the use of biometrics by the military in operations in Afghanistan and in Iraq as well. And as you said in your introduction, these provide concrete examples of how biometrics, or biometric databases or biometric technologies are set up for one specific purpose, and then that purpose suddenly shifts into something else, which then encroaches on the right to privacy and the right to anonymity, as will be seen with the US example. So in Israel, we have a situation where the Israeli government is not a stranger to the discussion about the use of biometrics and biometric technology. And this biometric technology is usually exported out into the rest of the world. But even at its very doorstep, Israel is using this technology specifically to target or against the Palestinians that, as we know, do not have a wide range of citizenship rights. So what does this look like in day-to-day life? The first situation that we get is Israel is really big on the use of biometric-based identity cards. And these biometric identity cards collect fingerprint information, sometimes facial information, and other related biometric issues. And then we have an issue as well of Israel now using facial recognition technology, for example, on automated checkpoints, which are located along the West Bank. So what this does is, in the past, you would have soldiers manning a checkpoint, but now they use biometric based technologies. It could be facial recognition, it could be fingerprint recording technology that's then used to automate the processes at checkpoints. And then there's also an array of various facial recognition and video surveillance technologies that are used within Jerusalem, within Israel, or without in the Palestinian areas. And the one argument that has been made or that has been advanced is how this shows that facial recognition technology and biometric technology is used to accompany a sustained military occupation, in this case, between Israel and Palestine. And as we go on, we find that it's targeted against a specific group of people or against a specific community. And that's one common thread that runs through the three examples that I'm going through in this presentation. And moving from the Israel-Palestine scenario, we move to Somalia, where again, unlike Israel, and now this is the difference in the context, unlike Israel, Somalia has for the longest time been considered a failed state without a centrally elected government or a stable government. But we also then see a lot of actors, in this instance, unlike Israel, which has homegrown actors developing and deploying the technology. In Somalia, we're seeing foreign actors in the form of either international donor organizations or humanitarian organizations, in the form of the African Union military forces or peacekeeping missions and forces, as well as US Special Forces, who work in the Somali region for different reasons, some to keep the peace, some to provide humanitarian aid, and some to fight migration and fight other internationally relevant topics or subjects like piracy. So we have externally driven interests that are coming together and funding the development of biometric technology and the creation of biometric databases, which again, because they are sponsored by various actors, we now, for the first time in our examples, see a combination of military and non-military uses of biometrics blurring and coming together. So, for example, a database which is set up by the Department of Defense may overlap with a database that is set up and run by the UN Refugee Agency or the International Organization for Migration. And it's in this blurring and overlapping of biometric databases where we are most likely to see abuses, especially around the reason why the information was collected and why it is now being processed by that specific agency or that specific unit. And since 2009, one reason that was advanced as in support of developing databases in Somalia was to fight or combat pirates or piracy of the Gulf of Aden, which is just off the Somalian coast. And again, it's been multinational efforts all converging for this one big internationally related purpose of fighting piracy. But then the issue is, in terms of law, in terms of, okay, you've caught people that are accused of piracy, it's not so easy to define what a pirate is. Some of the people that have been brought before courts in Kenya and all these other countries that prosecute or that assist Somalia to prosecute pirates are actually getting hold of legitimate fishermen who happen to be at the wrong place at the wrong time. And these fishermen are wrongfully accused of being pirates. After a prolonged case that wastes resources, they are then acquitted or let go or released. So there has been an idea to come up with a biometric registration of people that are fishermen and people that are pirates. But even then, the concept was good. But in practice, because the reliance was placed on local community leaders within Somalia to decide or to testify or to give evidence that person A is actually a legitimate fisherman operating out of the village, there was still room for pirates to bribe or to find ways to make it to that wide list of people that are not considered pirates, and vice versa. If a person or if an entity, a fishing entity, had issues with a certain group or a competing entity, they would then get those same community leaders to then designate legitimate fishermen as pirates. So we're seeing problems here about how the use of a biometric database specifically to fight piracy can be manipulated to disenfranchise other deserving community members from exercising, say, their right to work and earn a living as fishermen off the coast of Somalia. And it doesn't even stop there. The IOM has also come up with its MIDAS system, which is the Migration Information and Data Analysis System, which is mainly used to get the biometric information of people who are most likely migrating through or moving through Somalia for purposes of later on moving into Europe. And the MIDAS system is used across Africa in about 16 countries. And one of those countries is Somalia. Now, with the setting up of that MIDAS system, we see Western nation states actually outsourcing and externalizing border security to countries in Africa, such as Somalia. And this is for the purpose of identifying and preventing would-be asylum seekers from actually landing on European territory. And we're seeing this replicated in other parts of Africa as well, such as the Niger region, where in that instance, through the European Trust Fund for Africa, European Trust Fund for Africa, we see Europe actually taking an active role in how African countries actually manage their border security and even sometimes turn over information collected from those biometric data sets over to European countries. And this is a cause for concern because the right to privacy is clearly on the line. Then in my last example, we have the US military using biometric databases in its operations in Iraq and Afghanistan as well. This stems mainly from the Department of Defense, the US Department of Defense, which is driving this collection of biometric data. So the beautiful thing I loved about this example, which really shows the main driving reason behind why most countries use such technologies, because as part of the war on terror, which took off after the September 2001 events, the US actually declared that it wanted to deny people anonymity. And one way they did this was to simply collect as much information as possible. And rounding off, the common issues that we see across these three examples is that security or crime prevention concerns are frequently given as motivation for states to introduce such technologies, even if there is a lack of evidence which supports that the use of biometrics actually lowers the incidences of crime or even terrorism. And then, as the case of Somalia and Palestine show, counterterrorism opens the door for the misuse and abuse of biometric systems. And the other issue is that it's used to target people, whether it's fishermen, whether it's Palestinians, whether it's locals in a war-torn country. And the bottom line is that most of the time, biometric information or the use of biometric technologies is actually driven by profit models, companies who have an interest in developing and then exporting. And then the last thing that we've identified as PI is that there is need for greater transparency and greater accountability about how biometrics are used, because most of these technologies operate in a black, often proprietary box that doesn't reveal how the targeting works and why it works that way. Yeah, so those are my preliminary remarks, and I'm looking forward to engaging with everyone else during the plenary. Thank you.
Thank you, Coda. Very much appreciated. And just to say, I think from the mandate's perspective, one of the key issues for us is, of course, documenting the sort of on-the-ground experiences. One of the things we've consistently seen, I think, is a lack of, in some sense, of documentation of these sort of the real-time effects of the use of these technologies, in particular the overreach. And a thematic issue that it continues to resonate in a number of areas for the mandate is the ways in which counterterrorism looks like a small box, but de facto, as I say, it's not retail, it turns out to be wholesale, so that the broad spread use of the technologies, even if they're initially intended to narrow purpose, are often almost uncontainable and are in fact used by governments precisely because they offer a range of attractive shortcuts to collecting information, to monitoring populations, and to regulation, which traditionally haven't been available to states. And I think that really increases the importance of ensuring both control, oversight, and management of these technologies in human rights compliant ways. So we're really grateful for the work of Privacy International, in particular, the way it documents what these sort of practices on the ground. I'm going to turn now to Anna Maria. I'm going to remind our audience, we have a Q&A chat box. Would be great to get some questions. We know there are a number of experts. We're really grateful to see a number of UN entities online. We know that a large number of NGOs have joined us, and we know there's a lot of expertise on the call, so we'd really welcome the use of the Q&A function, the question and answer function. So over to you, Anna Maria, and yeah.
Thank you very much. I'll also start by sharing my screen. Hope it works. First of all, I'll start with warm thanks for inviting CTED, of course, and also already now compliments and congratulations to you, Professor, and your team on the establishment and the development of the report, which is very much timely, important on this critical topic that we have already established is something that we all definitely are exploring from this angle as well. Just to maybe a couple of quick words, if not all participants are familiar with CTED. We serve the Counterterrorism Committee, the CTC, which is a subsidiary body of the Security Council and was established after the terrorist attacks of 9/11. And subsequently, CTED, the Counterterrorism Executive Directorate, was established as a special political mission, and we are charged with assisting the CTC in its work to monitor the implementation of the Council resolutions on counterterrorism. And we do this through our expert on-site country assessments that already was referred to also, and we do this on behalf of the Counterterrorism Committee. The issue of responsible use and sharing of biometrics is integrated in our assessment and in our direct dialogue with the member states. And certainly when we do address this in a comprehensive manner during our assessments, I just want to mention that it is not only from the Council and CTED, but we of course benefit from the expertise and already instruments that are developed by our partners, and we do refer to them during our assessments and of course promote them to the member states, and especially all the human rights bodies of the UN, including the mandate is of course a resource, important resource for us as well. Change the slide, does not, sorry. Now, okay, so just briefly that there is the content, just setting the framework, and I just want to mention that all these elements that I will highlight are representing our approach to biometrics and how we represent this area during our assessment. So why, I will not, of course, now repeat anymore the mandate, just that the Council has recognized that the ability to compare biometric data collected, for example, during the course of border immigration vetting and investigations is an effective tool in response to the security threat posed by terrorists and FTFs. However, it is also recognized that this capacity presents complex legal and policy challenges and especially relevant to states' human rights obligations. How we approach this also, including in our assessment, is that incorporating the use of biometrics should be part of states' comprehensive border management efforts. So meaning that it's not to be implemented in isolation, which also hinders its effectiveness, but also the ensuring of the safeguards. So the first time the Council already addressed this was in 2016 in Resolution 2322, but as already mentioned, 2396 made it an international requirement when the Council adopted that resolution under Chapter 7 of the UN Charter. And this is in operative paragraph 15 of that resolution. The addendum was already also mentioned. The importance of the guiding principles is that this is the Council providing more elements on what it looks like to implement this capability. As Security Council resolutions by their nature are very ambiguous, as the professor already mentioned, they do not provide how-to, concrete guidance on how to. The addendum to the Biometric Guiding Principles is an effort to that direction, where the Council also highlighted some of the important human rights elements that I will refer to later on as well. The UN Compendium, this was also our attempt to provide more flavor and more meat to the bones of what does it mean to responsibly use and share biometric in counterterrorism context specifically. And this is a product that was developed under the Border Management and Law Enforcement Working Group of what is now called the Global Counterterrorism Coordination Compact, which means that we had all the relevant UN entities contributing to the compendium, but in no means it was meant that it is comprehensive, done, all good, but it is a living document. It was just to take the first step. And we were also partnered with the Biometrics Institute in developing this, and they served as the expert body and penholder for the compendium. But indeed, fully agree with Professor and Christina on the fact that there is still a need for absolutely more comprehensive guidance for member states. But the compendium serves as the first step that we will definitely elaborate. CTED is not a provider of technical assistance, but as Christina mentioned, many states still need assistance in this area, from policy to legal frameworks, etc. And this is where we, of course, work very closely with our partners, especially the UN Office of Counterterrorism, OCT, Interpol, etc., our close partners, and also look at where are the gaps and challenges that member states are facing. I will not spend too much time on this. Of course, the benefits of the use of biometrics are broadly already known in counterterrorism, and especially assisting member states and authorities to identify individuals, even if they present false particulars or attempt to impersonate another person. So this is an invaluable feature and can be used in tracking and detecting terrorists and disrupting their activities. One thing to remember, of course, that biometrics can also be used in proving or disproving individuals' involvement in an offense. So we also all, of course, know cases where individuals have already also been cleared using biometrics and as the technology advances. In our assessment, we also note that the choice of the best biometric modality depends on the available application and the business need of any states. We often advise that states should carefully evaluate their own use case requirements before investing new biometric capabilities. We refer to also procurement, and I'm happy to see now that the Special Rapporteur and your team has taken the business now also into more close view, which we haven't done so far in an extensive manner. And this is, of course, the other side of the coin where member states procure their biometric system. So very important. This is a challenge, as we know, as applications are constantly developing and expanding, and especially in the commercial sector, and advising states to focus on actual needs also actually facilitates their ability to put resources and focus on what are also the appropriate safeguards in terms of human rights, so that they don't just implement all possible what's out there from facial recognition to etc., but what is actually needed in their respective security environment. So then, of course, this critical area that I know I don't have much time. However, I want to highlight here that this is, of course, something that we are looking at and addressing in a comprehensive manner. And note that the human rights consideration must be integrated in every step. And this, we fully agree with the Special Rapporteur's approach, that in the establishment of the biometric system, but also in every activity taken based on a biometric match, for example. So security and human rights must go hand in hand and complement each other. And we recognize that the scope of the application of human rights, of course, differs hugely among member states and how it is implemented in their domestic law. However, as was said, we have a solid international human rights framework, and this is clearly, of course, stated in the Council resolution and in the addendum. And in addition, we have also Council language on paying particular attention to the need to the need to protect children and the children's rights. It has a reference to the UN Convention on Rights of the Child, and also the addendum refers to Article 7 of the ICCPR. So I find these very important elements that are integrated in our work. Reality is, of course, that states are increasingly using this, so advice and further guidance is definitely also needed more and more. And of course, the backbone to our approach must be to advise states that all the measures taken must comply with principles of legality, proportionality, and necessity, and any interference to privacy has to be based on law. And this we take very seriously in our assessment, and we do go through with the countries their legislation, existing legislation, and needs for amendments. And of course, there's a lot of talk about mass collection of this data without complying with the principles of necessity and proportionality, and this posing, of course, a severe violation of the right to privacy by itself. So we have, of course, looked at some of the good practices that I will not go more in detail here. Here they are listed, some of them, but for example, we do promote, for example, the mentioned by the Special Rapporteur on the need for impact assessments. This is something that we don't see yet many good examples from member states. However, this is definitely something we promote. Effective oversight bodies that should, of course, supervise the activities of state agencies, provide effective remedies in case of violations. And as this technology is based on collection, storage, and sharing and use of personal data, hence we cannot avoid this question and highlighting especially the privacy principles in a framework, for example, in informed consent, collection and use of only for the stated purpose. So the purpose limitation is something that we also look at very carefully. The last technical point from my side is, of course, the Council resolution also calls on states to share this data and especially mentions sharing with Interpol. And here we stress, of course, the same requirement should apply as domestically to, of course, sharing this information with other states, and requirements for request for any personal data should be based on genuine suspicion of terrorist activity, details of the evidentiary requirements, and establishing whether the data was obtained under oppressive conditions. Last slide, and I'm sorry, I'm extending my time a little bit. Here are the next step and resources. I'm happy that you to share this with all participants. You see here also we are looking at the impact of COVID-19, and especially suggesting that some states are taking hard security measures with public health crisis, but also what are the potential short and long-term implications to human rights. So please visit, this is a fresh report from CTED, the compendium, but also other sources that already highlight a lot of important human rights elements. So together, we look at these and integrate in our work, and together these already make a good source. And of course, as I said, we are now happy to welcome the Special Rapporteur's report and recommendations and promote them. So you can count on our support, definitely. And the last that you see there, please visit, is a dedicated website on biometrics. So please visit there, and we're happy to also upload the recommendations of the Special Rapporteur on this website. So I stop here. Sorry for extending my time. But thank you again, and happy to answer any questions.
Great, and just to underscore how much the mandate appreciates the dialogue that we have with UN CTED, we recognize we're in differently situated positions, and but we sometimes take different views, but we really feel ourselves to be in really positive and constructive dialogue with you, and just really welcome your support to the work of the mandate. And in particular, it's very positive to see the overlap, particularly around, I think, this specific issue of every stage, I think is particularly a keynote of the report, and welcome your remarks, Anna Maria, in that regard. I'm going to finally turn to our last speaker, Karen, and we are really delighted to have her with us, particularly focused in the EU context, but I know is going to speak to some of the broader EU and other dimensions of the practicalities of regulation in this space and the challenges she faces as a legislator in this context. So over to you, Karen, and reminding our participants that the chat is open, and we will go to it as soon as we've finished our presentations.
Thank you very much, and thank you for the presentation so far. It's been fascinating and interesting to follow the work. My presentation will be slightly less technical, more of a political point of view. I have some slides just to illustrate, but I'm looking forward to the Q&A session afterwards, and it's been very interesting to follow the work of the Special Rapporteur and also the presentations today. Let's see if the technicality of sharing my screen will work.
Karen, are you able to?
I will just try one more time, and then let's see. Otherwise, you will do without.
Or I can go to Katie, and she can try to open it at as we go. Oh, yep.
Is it there?
We see something, but I'm not sure we see your presentation. We've definitely got your screen, but possibly not the presentation. Oh, there you go.
I give up.
Got it. Perfect. Yes, you're good.
It was?
Yes, just the last one. So we can, yes. So now you just have to scroll it forward.
Perfect. So it's sort of a political view going through the present regulation on biometrics, and then also what we can be expecting in the future, and some of the perspectives from how EU regulation and what's happening within the European Union has an effect globally as well. One of the most important pieces of regulation in recent times on this issue is probably the General Data Protection Regulation that came into effect in 2018, which regulates personal data and the storage of, the use of, and also the right for the individual to have their data rectified or deleted. A problem with using the General Data Protection Regulation as a foundation for looking at biometrics is that it is very limited to only the data, and is also looking at data as something that can be changed, which is not the case when concerning biometric data, which is closely linked to the individual. Use of biometric data also has larger societal implications, which we need to, that are greater than just the use of personal data. If we look at the kind of data, biometrics data that has been used last year, before the European Parliament ended its last term for the elections, there was an agreement to start a common identity repository within the European Union, which is a big biometrics database, incorporating both the Schengen Information System, the Eurodac and the Visa Information System, as well as 3 new systems: the European Criminal Records, the Entry and Exit System, and the European Travel Information and Authorization System. The biometrics, just for the Schengen information system is both finger and pole mark, sometimes recognition, facial recognition, and also exchange of DNA profiles. So this is quite substantial biometric data that is being stored. And looking at the new system, which is part of the interoperability framework, the border management system, you see that it is both within border management as well as law enforcement, spanning a wide range of databases and wide range of uses, and concerns both EU nationals as well as third country nationals. There seems, though, to be a greater focus on the use of biometrics for EU nationals, whereas third country nationals does not, the use of biometrics there does not get as high a priority politically, unfortunately. Also, there has been recently quite a lot of debate on the use of the Schengen information system, access to data, also in Eurodac, by the United Kingdom, which has been highly criticized for not respecting the terms for the use of the data by the European Parliament. So it's quite interesting to see where this debate will be moving to when we see Brexit, the transition period for that ending, and what demands will be made to partner countries. Also sort of have the Five Eyes special partner countries for the European Union, the US, Canada, Australia, and the UK, and see what kind of requirements we will be having to these partners. For the future regulation, we've especially been looking at facial recognition, whereas since 2012, there has been a number of initiatives which has resulted in taking on this, which has resulted in the white paper from the European Commission on AI, looking at how do we regulate the use of facial recognition of biometrics when we're developing AI. And this was part of the initiatives from the new commission that was only put in place in December last year. And I think it's very important that they are aware of the specific risks for fundamental rights that this entails. And I think the work that we will be doing on this is crucial to looking at using artificial intelligence, and also because you need the data that is the foundation for the artificial intelligence needs to be of a sufficient quality, and as mentioned before, the collection of the biometric data and data needs to be well regulated. This is very basic slides. If you look at the European companies and the technology that they export, I think what we need to look more closely at is which are the tools that we as European legislators can be using, both within the regulation of the use of data within the European Union, which can then set a standard outside of the European Union. But we also need to make sure that European companies do not export tools that we're not accepting to be used within the European Union, and also that we make sure that tools for mass surveillance are not being exported to non-democratic regimes. Recently, about a month ago, we saw a ban on facial recognition by large tech companies such as Google, Amazon, Microsoft, and IBM in what is deemed as controversial circumstances. But I am not entirely certain that this is how the definition of controversial circumstances will be applied, and how we make sure that this is actually a sufficient protection for the global population. We've had a number of debates within the European Union during the COVID-19 crisis, especially concerning the use of tracing applications to trace who has been infected with COVID, who have you been close by using mobile phones. And I think it is crucial moving forward on the use of biometrics that digital rights, use of digital tools are fundamental rights. And this is not a question of giving up certain rights in order to have security, to stop terrorism, or to have good public health, but they are the respect of fundamental rights need to be applied also when ensuring other crucial factors in our society. And I think this is especially important when we're looking at the use of biometrics, because you can change your name, you can change what's difficult to your social security number, but you can't change your fingerprints or the way your iris and your eyes are, or your DNA. And that's why we need to be even more aware of what we're doing, how we protect fundamental and human rights all along the way when we are looking at biometrics. That was my brief political presentation. I'm looking forward to the Q&A. Thank you.
Thank you so much, Karen. And I think in particular, as the report addresses, there's a really significant role for legislators here. And the report makes a number of recommendations in terms of the ways in which some of these principles could be translated into specific and concrete legislative measures to better protect both security and rights, because the mandate is very much in concert with you that we don't see these two things as separate. A world without security is not one any of us want to live in, but a world where we are fully secure and have no rights is not a dignified life for most people. And so I think the indivisibility of these two things. So let's pick up on a number of questions. We'd have a very active chat, and I'm going to invite the very first question from Nicholas Miller from ICNL, and we can unmute you, Nicholas, if you would like to ask your question in person, or we can ask it themselves. So Nicholas, if you'd like to ask it, go ahead.
Thank you, Fionnuala, and I'd first like to reiterate my thanks for this excellent event and the much needed report. My question has to do with the technical assistance being offered to meet state obligations established under the Security Council resolutions discussed. And I'm particularly interested in what the mandate's view on current efforts to provide technical or financial assistance by the UN are, and as well, if these efforts have sufficient provision for human rights safeguards to be included in the efforts of under-resourced states. And finally, if not, what challenges are there that prevent us from addressing this within the assistance provided? Understanding, of course, in context that the UN is one actor providing technical assistance, and that the provision of assistance by other actors may complicate this somewhat. Thank you.
I'm going to make one or two brief remarks and then turn to Christina to speak to how this is addressed in the report. As many on the call will be aware, the mandate has held a consistent position that UN entities are bound by the human rights obligations that we hold states to. And we also consistently remind entities of the due diligence obligations that flow from the work that we all do within the UN space. We have been concerned, but I think I would say as a general matter is this sort of, if you want, silo of counterterrorism in one box and human rights in the other, which means that there's a lot of information that we know about states' compliance with human rights as a general matter within the UN system through Universal Periodic Review, through the review of treaty bodies like the Human Rights Committee, through the country visits of the Special Rapporteur that document meticulously the state of compliance. But in reality, those are often not wholesale applied over. And the reality is that we have many states with serious human rights records and a persistent record of violating human rights and targeting a wide range, particularly civil society and other actors, under the guise of doing terrorism or counterterrorism. And so one of the biggest challenges in the technical and capacity building context is in fact bringing these two things together, understanding that the information that's relevant about a state's human rights record is absolutely relevant to the kind and form of technical assistance and capacity building you give them, particularly when that capacity building is sort of parachuted into their security sector and functions to actually enable and in fact often optimize or give greater capacity to the state to use a whole range of powerful coercive tools to in fact implement new technologies. And we do see gaps, significant gaps. And this is not the fault of CTED, but the structure of the CTC reporting mechanism is such that we have no idea what states' assessments are. And the reality is every report I write or every report that a human rights body writes is public, and states know what's being said about them, and we understand where they're falling short. And that transparency gap is huge because it disables us from really understanding where there are really challenges with technical assistance and capacity building into states that already have human rights problems and human rights records that are problematic, and where technical assistance and capacity building in the CT space may actually compound or augment those problems. I'm going to ask Christina to say a word or two, and then I do want Anna Maria to also just reflect on, I think, really some of the challenges maybe that CTED face structurally by the fact that we have a structure of accounting that is a rather closed one in the CT space. So Christina, maybe from the report, and then Anna Maria.
Thank you very much. I do not have actually that much to add to the points that Fionnuala has already made. As I flagged earlier, and as we also note in the report, of course, with respect to the obligations imposed by Resolution 2396, and in particular, the obligation to develop biometric systems, there is a huge capacity gap on part of many member states. And the UN is very well placed to assist the states to try to bridge that gap. At the same time, it is important that whatever technical assistance and capacity building projects are implemented are fully human rights compliant, and that human rights considerations are comprehensively included in these projects. Now, the mandate works with a number of entities from the UN Global Counterterrorism Coordination Compact on developing more generic thematic guidance on a number of issues. However, we do not have a lot of information on the particular biometrics related technical assistance programs that certain entities may be implementing. So I cannot really comment on any of them in particular. The reason why the mandate thinks that there is space for additional input and possibly for improvement is on the basis of existing guidance that we have seen, whereas both Anna Maria and the Special Rapporteur have flagged, there has been an attempt to include a human rights component, but we feel that there still is a considerable gap if we want to properly mainstream the fourth pillar of the global counterterrorism strategy. And that's one of the reasons why this research and report has been implemented. And we hope that this can be a tool that we can actually use to support other entities from the Global Compact who are actually conducting state or regional capacity building. And I hand over to Anna Maria, who probably can say a lot more on this issue, even though CTED is not involved in technical assistance in this respect.
Thank you, and excellent question. So yes, we are not direct providers of technical assistance. However, we do have a mandate to facilitate it, which means that certainly we work very closely with our implementing partners, and I can assure you that definitely all human rights elements are cross-cutting in whether we talk about biometrics, watch listing, API, PNR, to legal frameworks, etc. So in our assessments, absolutely. We always, when we go to member states, we always have a human rights officer part of the delegation, and this is covered extensively in our reports. And indeed, We do need to, of course, respect the confidentiality of those reports. However, of course, we do promote for member states that in our mandate renewal in Resolution 2395, we were given more sort of also encouragement to especially share our recommendations, which derive from our assessment, which we do share with the implementing partners. And there, of course, they're all categorized in a way that flag that whether, if it is, what is the issue, what is the gap, what is the challenge for that particular member states. And there definitely these are very often the issues, and we try to look at comprehensively. It is not just that you have human rights issues in biometrics or watch listing. However, usually it is an issue of the entire legal framework. On the TA programs and projects, I can say that we have made a lot of improvements, and I also give compliments to OCT, the Office of Counterterrorism, which has done a lot of work, and I think the Global Compact has really taken steps to the right direction, where all projects and programs, it is mandatory that we actually put their human rights and gender elements of each and every program and projects. None of them go through unless we have covered those issues comprehensively. So that, I think, is already something positive, that when it comes to any TA program or project, that is a mandatory part. Yes, there's a lot of improvement, but I think we have taken and we have already seen positive action to that direction, and I hope we can improve more.
Yeah, I appreciate that. And so we have about 8 minutes left, and I'm going to do a lightning round of questions to try to get through some of the very excellent questions we've had on the chat. There were a couple of questions directed to CODA, in particular questions that related to the role of IOM in data collection, and also the question as to whether or not CODA there were concrete examples of how things could be better in any one of the three situations that you've identified. So I'm going to ask you to take 2 minutes, and then I'm going to ask each of our panelists to think of, if they can, one example of good practice, because we've had a question about, is there anything good to say in this space? And then I'm also just going to ask you all to reflect on the question. There was a question from Mr. McCann on the Q&A, asking whether or not this is from UNDP, actually, I believe, whether or not this is how to explain this as a wholesale or retail. The question is, do these biometrics only apply to known terrorists or to everyone? And I think there I would just remind us all that we have no global definition of terrorism. So people get to define terrorists at the national level however they like, which they appear to do quite a bit at the state legislative level. So let's start with CODA. The two questions to you. Let's do a lightning round on one good practice, if each one of you could think about one good practice, and then let's focus on this question of just scale. Like, who's actually in the frame of the target. So let's start with you, CODA, and I'm going to ask us all to be sort of in the 2-minute range, please.
Thank you very much. I'll start with best practice. I would say that the recommendations that are in the report are really solid, and if each of the sectors, whether government, business, were to pick up the recommendations directed to their sector, they would be really good. But if I was to identify two major recommendations, I would say that there's always need to have risk assessments before biometric technologies are rolled out. And these risk assessments are to also determine whether it's actually necessary to even use the biometric technology in the first place. And to accompany that assessment, I would also say there should be solid evidence that the use of biometric technology will actually bear fruit that is proposed. And I would say the second one is also around the issue of necessity. Sometimes it's not necessary to go on these massive drives to collect biometric information. And yeah, I would say those are the two recommendations, but I would really recommend that people, if they can't go through the whole report, they can just flip through to the last 3 pages. And if they just implement half of what's there, they'll be on a pretty good path to proper biometric practice.
And we just by accident, of course, translated those, so to make sure they're widely available. Karen, why don't you respond? And just to those participants, we run slightly over to get through the questions. Karen.
I think a question of good practice is always trying to reduce the amount of data that you are collecting and storing, and that you store it in the most appropriate way. I think actually the political discussion and the guidelines that were adopted on COVID-19 tracing applications within the European Union is actually an example of good practice. There was a toolbox developed by the European Commission. They produced guidelines, and most member states actually follow these guidelines, which resulted in, together with Apple and Google, to not store individual data about your health status, but only having non-personal tokens stored decentrally. And I think if this could be a way forward, cooperating both with the technology companies and also with regional on looking at how do we ensure people's rights as well as seeking the objectives that we're looking for.
Great. Anna Maria, best practice, your one thing that you think you've seen that is good practice.
Well, thank you. I would probably raise that we've seen some good practices from member states on mitigation strategies. And that is something that where I would flag, especially that undertakes regular testing. We've talked about of course, the assessments on privacy impact, etc., but also testing the whole system. And that is often the issue that leads to, of course, a lot of potential risks and threats, but to really test the entire system so that all the risks are exposed and understood. This is often the case for member states, that it is not necessarily that they take up on this technology and then not understand. And then if you don't understand and actually calculate the risk, you don't also know how to develop proper and appropriate mitigation measures. So this is something. Maybe I will take the opportunity in essence of time to also answer that. Thank you, Neil. A good question on of course, the resolution explicitly says that the purpose, identify terrorists and FTFs. No, it does not say that member states should collect everyone or just terrorists. Of course, the resolution is a counterterrorism resolution. However, how we tackle this with member states is that we look at their legislation against Security Council resolutions, as well as all the 19 international conventions and protocols on counterterrorism, which do define terrorist offenses. And that is how we look at the whole framework and criminal laws and terrorist laws of member states. And then that leads us to set the framework for such tools for border management as well. So not a perfect answer, but that is basically how we look at it. Thank you.
Christina.
Thank you. My example is not actual good practice. It's more encouraging practice that could be developed further and that could be built on. And it relates to our recommendation for states to develop licensing and authorization systems. And in this respect, we already have a couple of examples of regional and international initiatives, including the Wassenaar Arrangement on export controls for arms and dual-use goods and technologies, as well as the EU's regulation that sets up a community regime for the export and transfer of dual-use goods. And both of these initiatives, both of these frameworks have their own challenges and limitations, and they also are not broad enough to actually cover a number of the biometric tools that we were addressing today. However, they provide for a very interesting and useful model that states could build on if they are actually committed to develop authorization and licensing regimes for biometric tools that could cover actually more than just exports, but development, transfer, and sale of these technologies. So that would be my good practice, or well, encouraging practice. And I would also like to follow up to on the response by Ana Maria relating to the question by UNDP, which is indeed a very good question. It is something that we have discussed quite a bit in Global Compact working groups. And one of the things that the mandate has been flagging and that we are somewhat concerned about, of course, the Security Council resolution, for example, when they are talking about watch lists and databases, they refer to known and suspected terrorists. But in addition to terrorism not being defined, it is also not defined what is meant by known and suspected terrorists. And we know that the scope of the measures, of course, is broader than the scope of criminal law. So when we're talking about suspected terrorists, we're not talking about a suspect in the criminal law sense of the word. And even though the mandate did not have the chance to produce comprehensive research on how different jurisdictions define these terms, but what we very clearly see is that many jurisdictions lack domestic definitions, or if they do have domestic definitions, these are not legal definitions, but policy definitions, and frequently quite broad. And of course, if we implement the measures by the Security Council, provided by the Security Council against these resolutions, we will end up with a much broader scope than perhaps was intended when the resolution was passed. That's it.
So that question of broadness and breadth continues to really concern the mandate. And I would say those of you who followed the mandate's assessment of national legislation, which is found on the website of the mandate, we do comprehensive reviews of many states. You will see that without exception, we see a real broadening of definition, a move into pre-criminal space, and a lack of rigor and clarity, which goes to the fundamentals of the rule of law, which is you can only be responsible under law for things that are known. And for things that are not clear, I think we clearly move out of a rule of law framework, or a rule of law framework that's really problematic. Let me close by thanking you all, and we're really delighted to have had this event. We're really pleased to be launching this report. We bear in mind the core recommendations, which are the need for a comprehensive assessment of human rights implications, the need to ensure compliance for human rights at all stages of data usage, to recognize the challenges of automated processing, and finally to focus on the role and the responsibilities of businesses. And we will be at RightsCon, so those of you who are joining the RightsCon discussions, join us on the 30th of July for further discussions about the mandate's informations and thinkings about technology, law, and human rights interface in the CT space. And finally, we look forward to working with many of you over the next year as we take this report out to key stakeholders and develop our principles on the use of human rights compliant biometrics in the counterterrorism space. So thank you all for joining us today.